Good afternoon. We'll be on the record on this matter. This is Jefferson County case 20-2417, State versus Jesse Gentle. Mr. Gentle is here in court in person with his attorney, Mr. Archibald, and Mr. Stosich. The state is appearing through Mr. Stavinsky, Deputy Prosecuting Attorney for Jefferson County, and has a representative from the Jefferson County Sheriff's Department. Mr. Stavinsky, do you want to identify who your representative is with you at the council table?
Yes, Your Honor. It's Detective Jason Pettingill.
All right, thank you, Officer Pettingill. The issue before the court's been advised there's been an agreement reached to potentially resolve this case. It's currently set for trial, I believe, next summer. There's been a motion filed to amend the information in this case, and the court has signed that order for the amendment of the information to the charge of voluntary manslaughter. And there's been a written plea agreement that's been filed with the court. Mr. Archibald, you wish to proceed with that change of plea pursuant to that plea agreement today?
Yes, Your Honor.
Very well. Mr. Gentle, as a first matter of business, I do want to just do an initial arraignment of this amended charge with you, make sure you understand the nature of the charge and the potential penalties on this amended information. It is titled an amended prosecuting attorney's information. It was filed with the court on October 19th, so today. You received a copy of that, Mr. Gentle?
Yes, sir.
Very well. Go ahead and just pull the microphone up to you so you can be heard. This information states your true name is Jesse Sterling Gentle. Is that correct?
Yes, sir.
It sets forth in this amended information the charge of voluntary manslaughter pursuant to Idaho Code Section 18-4006, subparagraph 1. You're advised that that is a felony offense in the state of Idaho, has a potential penalty of up to 15 years in the penitentiary and or a $15,000 fine. There's also the potential for restitution to the family of the deceased for funeral expenses or matters of that nature. There's also the potential of a civil penalty in favor of the family of the victim up to $5,000 in addition to and separate from any restitution that I just discussed. So you understand all those potential penalties, Mr. Gentle?
Yes, sir.
Very well. This charge and the charging language alleges that the defendant, Jesse Sterling Gentle, on or about November 17th, 2020 in Jefferson County, Idaho, is unlawfully, but without malice of forethought and premeditation, kill Merle Jay Sorensen, a human being, by shooting him with a firearm from which he died. So that's the charging language of the allegation against you, Mr. Gentle, and is the subject of this plea agreement. So you understand that charge and the elements of that charge, Mr. Gentle?
Yes, sir.
Very well. So the change from your original charge, which is first-degree murder, is that there's no longer the required element of showing premeditation. There's also no longer the showing of malice or forethought under this voluntary manslaughter charge. So you understand that change?
Yes, sir.
Very well. So there has been a plea agreement that's been entered into this case and filed with the court. Mr. Gentle, I'm going to go through that here in just a moment. I do want to, just for the record, to place that plea agreement on the record. It provides, and I'll ask the state and Mr. Archibald to just confirm that is in fact the wording of the plea agreement. It provides that the defendant was charged with murder in the first degree on November 17, 2020. The state of Idaho filed a notice of intent to seek the death penalty on May 10th of 2021. Paragraph 2 provides that the defendant agrees to plead guilty to an amended charge of voluntary manslaughter, a felony pursuant to Idaho Code 18-4006, subparagraph 1. The murder charge and the death penalty will be dismissed. Paragraph 3 provides that the defendant will ask the court to sentence him to 10 years in prison and then 5 years of parole for a unified sentence of 15 years. I just want to clarify, Mr. Gentle, my understanding of that is that you and your attorney will be asking the court at the time of sentencing that I impose a sentence of 10 years fixed, 10 years fixed with a following indeterminate term of 5 years, so for a total sentence of 15 years. It's just a little different wording. It states 5 years of parole. That assumes you are actually paroled after serving that 10 years. I'm just trying to clarify for the record that the actual sentence you're asking the court to impose is going to be a 10-year fixed sentence with a 5-year indeterminate period to follow. So that your understanding of the request you're making, Mr. Gentle?
Yes, Your Honor.
That 10-year fixed means that you would not be eligible for parole until you serve 10 years. In fact, that's the sentence I impose. So you understand that?
Yes, Your Honor.
So the next paragraph provides in paragraph 4 that you, Mr. Gentle, agree that the state of Idaho, at the time of sentencing, is going to be asking the court for me to require you to serve a minimum 15-year prison sentence. So in other words, the state's going to come to sentencing asking me to require you to serve the full 15 years as a fixed sentence without any eligibility for parole. So you understand that?
Yes, Your Honor.
Paragraph 5 provides that I will be given the opportunity to consider all aggravating evidence presented by the state and any and all mitigating evidence presented by you and your attorney at the time of sentencing. You'll be given credit for time that you served in jail against any sentence that I impose. Paragraph 7 provides that you understand the nature of the charge to which you're agreeing to plead guilty. You agree you've not been coerced into pleading guilty. You understand the consequences of pleading guilty, including the maximum penalties that may be imposed. You understand that by pleading guilty, you're waiving your right to a jury trial, the right to confront your accusers, and your right against self-incrimination. I'm going to go through all that in a little more detail with you. Mr. Gentle, is that accurate what your plea agreement provides?
Yes, sir.
You're also agreeing to pay restitution as ordered in court, which I just described to be things submitted by the state for restitution. There could potentially also be costs of prosecution. The investigation of this case is another part of restitution that could be requested of you, Mr. Gentle. So you understand what restitution is?
Yes, sir.
Paragraph 9 provides that any other conditions not expressly agreed upon in this written plea agreement, that the parties are free to argue as they see fit at the time of sentencing. So in other words, anything that's not addressed in this written plea agreement, both parties agree to argue as they feel so necessary at the time of sentencing. You understand that?
Yes, sir.
It also provides that paragraph 10 that you're satisfied with your legal representation you've received with your attorneys, you have reviewed with your attorney all possible defenses you feel you may have, and that by this plea of guilty you voluntarily waive those defenses. You have received the advice of counsel and enter into this agreement knowingly, intelligently, and voluntarily. Is that correct, Mr. Gentle?
Yes, Your Honor.
Very well. All right. The final part of this plea agreement provides that this agreement is not binding on this court, and that's a very critical part of this plea agreement that you need to understand. specifically as it relates to the sentencing recommendations that are contained in this agreement. None of that is binding on this court, but that's an agreement between you and your attorneys and the prosecuting attorney for Jefferson County. The recommendations will be made at the time of sentencing. I'm not bound to follow any of those recommendations, so you understand that?
Yes, sir.
All right, so what that means is I'm gonna, if I accept your guilty plea today, I'm gonna order, we'll call it a pre-sentence report. That report's gonna tell me a lot about you and your history and your background. It's gonna tell me a lot about any criminal history you have, your work history, family history, social history, any mental health issues that may exist, any substance abuse issues that may exist, any prior probations, if any, and how you performed on probation. And it's going to contain its own recommendation as whether or not you're a candidate for probation or incarceration. It will not recommend any specific length of incarceration, but I'm going to take all that information into account at the time of sentencing and make my own determination as to what's the appropriate sentence in your case. So you understand how that will work?
Yes, Your Honor.
Obviously, I'm bound by the maximum potential penalties for the charge, which is, as I've just described for you, 15 years and or $15,000 fine in restitution. All right. Mr. Archibald, this agreement has a further paragraph that is acknowledgments that, as I have stated, that plea agreement for the record up to this point, is that fairly safe the agreement in this case?
Yes, Your Honor.
Mr. Stevinsky, do you agree?
Yes, Your Honor.
Very well. Right, Mr. Archibald and or Mr. Stosich, do you feel like you've had sufficient time to discuss this case with Mr. Gentle before he enters a plea of guilty in this matter?
Yes.
And I know that you've been appointed as when this case was filed as a potential death penalty matter, and that you've been provided access to a resource judge to conduct an investigation, to hire, potentially hire experts to assist in defending Mr. Gentle, and without disclosing, I guess, the confidentiality of that information, have you had an opportunity to access those resources and conduct that necessary investigation?
Yes, Your Honor. Under the APA guidelines, we have complied with we have had a psychologist involved in this case, a neuropsychologist, a fact investigator, and a life history or litigation investigator. We have, the county has been good about paying those bills when presented, so we have complied with those guidelines.
All right, thank you. Under all the circumstances, you consent to your client's plea of guilty today?
Yes.
Very well. Before Mr. Gentle, I'm going to ask you a few additional questions here. I'm going to place you under oath for that purpose. Before I do that, though, I want to inquire, I don't want to overlook this. Mr. Stevinsky, on behalf of the state, I want to make sure that the victims' rights provisions are being complied with in this plea agreement. As the state feel you've complied with those victim rights requirements by consulting with the family of the victim in this matter as part of the negotiations in this plea agreement?
Yes, Your Honor. As much as we could, the family of the victim hasn't been reaching out to us, so we actually haven't had any specific contact about this plea agreement, but we make everything possible to reach out to them.
As far as you know, are there any victims been notified of the hearing today? I don't know if they're present today, but you're representing that your office has at least made those efforts to reach out to the family of the victim?
Yes, Your Honor.
Well, obviously, that's another, well, let me, first of all, Mr. Gentle, I need to place you under oath and ask you a few questions to simply confirm that you do know what you're doing here today, that your plea is being entered freely and voluntarily. If you'll please stand and raise your right hand. I know that might be difficult there, but
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Okay, go ahead and be seated again there, thank you. Mr. Gentle, I've asked, we've had quite a bit of discussion here before I place you under oath. Now you are under oath, or all your responses to the questions I posed to you earlier today, are they all true and correct? Anything you feel like you need to correct, or any comments you'd like to make here before you go further now that you're under oath?
No, sir, not that I can think of.
I'm sorry, I can't hear you.
No, sir, not that I can think of. I just want to deeply apologize
All right.
for being brought to this situation.
All right, well, you'll have an opportunity to make those statements at the time of sentencing. Appreciate your comments. So, Mr. Gentle, I've asked your attorney some questions about their representation. Do you feel like you've had sufficient time with Mr. Archibald and Mr. Stosich to discuss this case with them?
Yes, sir.
Have you told them everything you know about the case and discussed any potential defenses you feel you may have?
Yes, sir. I've talked to them quite thoroughly.
Are you satisfied with their representation?
I am.
And you feel comfortable going forward with this plea of guilty based upon their advice and representation?
Yes, Your Honor, I do.
All right. Do you feel like anyone's forcing or pressuring you to enter this plea of guilty today?
No, sir, not at all.
You feel like you're doing this freely and voluntarily after discussing it with your attorney?
Yes, I do.
Would it be fair to say that you're pleading guilty today because you, in fact, feel you are guilty of the charge?
Yes, Your Honor.
All right. And your attorney discussed the investigation that they have conducted. You feel like that they have had those conversations with you to discuss their investigation, and you're comfortable with their representation at this point?
Yes, sir, I'm comfortable with the way they've been representing me.
All right. You feel like you understand what we're doing here today?
Yeah, I do, sir.
Are you on any medication that might be?
Hang on a second, Your Honor. Would you go ahead and repeat that?
Yes, Your Honor. What was the question?
No, I just asked you,
You might forget the idea of what we're doing.
okay, when you say a good idea, I want to make sure you have a clear understanding of what we're doing here today. And that's what all purpose of this hearing is today. If you feel like you have any questions, you want to talk to your attorneys, just let me know, and I'll give you an opportunity to talk to your attorneys. All right?
Okay, thank you, sir.
All right. You're understanding my conversation here today, correct?
Yes, sir.
All right. Are you taking any medication that might be affecting your ability to think clearly this afternoon?
No, sir, I will take medication.
All right. All right. You feel like you have any psychological and mental issues that might be affecting your ability to understand what I'm talking with you about today?
No, sir.
And we've discussed the charge in this case. You feel like you understand the nature of the charge against you of voluntary manslaughter?
Yes, sir, I do understand.
All right. You've had a chance to review that with your attorney and what the state would have to prove in that charge and what you're pleading guilty to?
Yes, sir, we've talked about that.
All right. You understand those potential penalties that I discussed with you in the plea agreement?
Yes, sir.
You understand the non-binding effect of this plea agreement on the court?
Yes, sir, I understand.
I want to make sure you understand the reason I'm going through these questions with you today and placing you under oath is that once you plead guilty, it's an important decision, and it's not a decision that's easily taken back. If you were to file a motion tomorrow or next week asking to withdraw your plea of guilty because you've changed your mind and no longer want to plead guilty, you would have to show me some good cause of why I should allow you to do that. Because today I'm asking you these questions to make sure you do understand what you're doing, that you're doing it freely and voluntarily, that nobody's pressuring you to do it. And so if you were to come back to court and want to withdraw your plea of guilty, you would have to convince me with some other good cause showing why I should allow you to do that. So you understand why I'm asking you these questions today?
Yes, I understand the reason, Your Honor.
All right. And you signed this plea agreement that contains this language, but I want to make sure you, also it's clear that you understand that by pleading guilty today, that you'll be waiving your right to have a jury trial. This case was set for trial next summer, although it was on a much more serious charge of first-degree murder with potential death penalty. But by pleading guilty today, there'll be no trial. You understand that?
Yes, sir.
The state no longer has the burden of proving the charges against you because you're admitting those charges. You understand that?
Yes, Your Honor.
You're waiving any defenses you may feel you have to the charges by pleading guilty. You understand that?
Yes, sir.
You're also waiving your right against self-incrimination because by pleading guilty to voluntary manslaughter, you're admitting that you committed a crime of voluntary manslaughter. And in that way, you're incriminating yourself. So you understand that?
Yes, sir, I do.
All right, so Mr. Gentle, I'm going to ask you your plea to the charge in this matter on the amended information that's been filed with the court. So to the charge, Mr. Gentle, you have that in front of you, to the charge of voluntary manslaughter as alleged in this amended prosecuting attorney's information. How do you plead to that charge?
I'll plead guilty, sir.
Very well. This charge alleges, as I've summarized previously, it alleges that this event occurred on or about November 17th, 2020 in Jefferson County, Idaho. Is that correct? Is that where this happened?
Yes, sir, it is.
It alleges that at that time that you did unlawfully, but without malice aforethought and premeditation, kill Merle Jay Sorensen, a human being, by shooting him with a firearm in which he died. Is that a true statement, Mr. Gentle?
Yes, sir, that's a true statement.
That's what happened?
Yes, sir, it is.
Very well. Anything about that allegation that's not true, Mr. Gentle?
No, sir.
Very well. Well, if the court finds that your plea is freely and voluntarily entered, Mr. Gentle, that you understand the nature of the charges and the amended information and the potential penalties, that you understand the rights that you're waiving by entering this plea of guilty, and as indicated, the nature of the offense. So the court accepts your plea. I also find that there's a factual basis for your plea of guilty based upon your acknowledgement of the allegations and the information. So I'll accept your plea of guilty and enter the record. I'll order the pre-sentence report that I just discussed with you. Counsel, how long of time frame do you feel like you're going to need for a sentencing hearing? Obviously, typically we set these for 30 minutes to an hour, but this may be a case that requires longer than that. Mr. Archibald, how much time do you feel you need for a sentencing hearing?
I think either a full morning or a full afternoon. I don't think we'll need a whole day.
Mr. Stavinsky, think a half a day would be sufficient for sentencing?
Yes, sir.
Very well. Well, I think with the pre-sentence reports take at least 8 weeks to prepare, that puts us right on top of the Christmas holiday week, so I don't feel inclined to set this sentencing during that time frame. So I'm going to propose that we have the sentencing either January 11th or January 25th for the afternoon. Now, that's a Tuesday afternoon that I set aside for hearings to take longer than my typical long motion calendar. So the afternoon of Tuesday the 11th or Tuesday the 25th. Any preference, I guess, Mr. Stavinsky?
11 works for the state, right?
Mr. Archibald?
Either of those time frames work.
All right. Well, let's set this matter to begin on Tuesday, January 11th at 1:30. And we'll just set aside the afternoon and not set any other matters on that day to give us plenty of time. Counsel will be given plenty of opportunity to present any testimony in aggravation or testimony in mitigation. Letters of support that can be attached to the pre-sentence report, and letters in aggravation that can also be attached to the pre-sentence report for the court to consider. Let me fill out this order.
Because he's been incarcerated since November, I don't know that a gain assessment will be needed. There was, of course, drugs involved in this case, so I don't know if the court wants a gain assessment or not.
Well, you're correct. He's been in custody long enough that we may not be able to do a valid gain assessment. I'll order it, but they may just comment that they couldn't conduct it because of the length of time he's been incarcerated, and they can do any substance abuse evaluation as well. And obviously, you can supplement that with any information you feel I should have. There's a pre-sentence report cover sheet that needs to be filled out, that Mr. General's in custody, and counsel to fill out what needs to be in that cover sheet, that the pre-sentence investigator can just revise that Mr. Gentle is in custody in the Jefferson County Jail for purposes of conducting their interviews and their testing. Anything else that we need to address? I know we talked somewhat in chambers regarding Mr. Archibald's continued representation since his charge has now been amended. In that regard, based upon Mr. Gentle's plea of guilty, we will vacate the jury trial that's currently scheduled for next summer. And once the sentencing has occurred, the state can file their motions, I guess, to dismiss the murder charge and the withdraw the death penalty notification based upon his plea of guilty to this voluntary manslaughter charge. My position we've discussed is that I feel that Mr. Archibald should remain on as co-counsel on this case until the time of sentencing. Although the death penalty at this point is not an option based upon the plea to the lesser offense of voluntary manslaughter, there are still procedural matters that could occur that are unknown at this time, such as if Mr. Gentle tried to withdraw his plea of guilty, and if the court were to allow that withdrawal of his plea prior to sentencing, then the original first-degree murder charge and death penalty would be reinstated. So there is still the potential for that to occur. Obviously, we don't know if that will even occur, but it's a possibility. And so just for that reason and the continuity of counsel based upon the investigations that have been ongoing here, and the fact that the Capital Defense Fund will reimburse Jefferson County for the cost of Mr. Archibald's representation, so it's not a burden on the county to have him continue in his representation. So that's your understanding, counsel, Mr. Stosich and Mr. Archibald.
Yes, thank you.
Yes, it is, Your Honor, thank you.
Mr. Stavinsky, does the state have any objection to that or comments you'd like to make?
No objections, Your Honor.
All right, on that basis, just so it's clear for the record that Mr. Archibald should remain on the case as co-counsel through the time of sentencing, at which point the likelihood of pleas being withdrawn or those issues occurring would be minimized to a larger extent. So that'll be the order of the court. If you need anything from the court in that regard to formalize that with the Capital Defense Fund, I can do that. Mr. Stavinsky, anything I've overlooked for purposes of today's change of plea hearing?
No, Your Honor, thank you.
Mr. Archibald?
No, thank you.
All right. Very well. I appreciate counsel's efforts. These are very difficult cases for everyone, the state, the defendant, the victims, the defendant's families. And so I'm glad there will be some resolution. Obviously, it's yet to be determined what the ultimate outcome is at the time of sentencing. Mr. Gentle, a pre-sentence investigator, will be to the jail to interview you, unless they set it up as a remote interview. interview on Zoom. You have the right to have your attorneys present during those interviews and to continue representing you through that pre-sentence report investigation process. So obviously your attorneys are there to assist you. And we'll be communicating with you. So if you have any questions for the court today, very well. Thank you for your appearance, and parties can be excused and gently be remanded to the Jefferson County Sheriff's Department until the time of sentencing on January 11th. So you may go ahead and be excused, and the court will be in recess.
Please rise.